right, let's go ahead and we're going to get things started. So today we are going to talk Gar contracts, editing, layout, setup. This is something I think the last time I did this class was early part of this year. Some recent events, some things that we've been seeing coming into the help desk, and some editing that we've seen done on contracts that would indicate that we need to refresh on this a little bit. Okay, so you guys know most of the content for these types of training are coming from stuff that's happening in our brokerage at that time. So it's a good opportunity to review this. So I am going to jump right into it. We're going to do a little bit of PowerPoint stuff. We're going to play around a little bit, and we might even have enough time for a demonstration of editing a contract in real world situations with using Docs Plus. Okay, so basic information here. We're going to start, and I am going to share my screen, see if I can get it on the right one. Okay, y'all looking at the PowerPoint now? Thank you. All right, so editing Gar contracts. So before we get too far into it, let's talk about some basic information about Gar contract documents. All right, as a review, some general principles of Gar contracts. Exhibits are going to be labeled A, B, and C. Amendments, on the other hand, are going to be labeled 1, 2, and 3. So somebody explained to me very briefly the difference between an exhibit and an amendment for the brand new licensees in the room or on the call.
An exhibit is something that you're putting into the contract, like an HOA, a card. An amendment is something that needs to be changed from the original purchase sale agreement.
Perfect. Well said. Absolutely. Okay. Thank you very much, Claire. Another principle of Gar contracts. There are a few things that should never be edited, never be changed, or edited by you as an agent. And those three things are the seller's property disclosure, the community association disclosure, and completion of only your side details of the lead-based paint exhibit disclosure. Why is that? Anybody want to take a guess?
I don't want that liability, for one. I don't want to touch that disclosure.
Amen to that. Sean, you may remember this. Back in the old MSRE days, one of our agents, whose name is escaping me at the moment, I'm having a total brain cramp right now, ended up paying for a $1,200 refrigerator because his client asked him to check that box off on the disclosure, and turned around and he forgot about it, and at the closing table discovered, hey, that refrigerator's not there. He went, took his commission check and went and bought a refrigerator for his clients.
Cooper Smith. Yep, I will not forget that. That's why I learned my lesson from him.
It was Cooper. Here we are telling this story, what, 6 years later? For those of you who don't know, Sean and I used to be in the same brokerage way back 100 years ago. And we're glad to be working together again. So, of course, your name, with the exception of the lead-based paint exhibit, your signature is not on either one of those seller's property or community association disclosures. So that means you don't have a dog in the fight. And you do not want that liability. That is a disclosure between the seller and the buyer, has nothing to do with you. However, you do have a responsibility to make sure that it is filled out as accurately as possible and as completely as possible. Okay, so you need to monitor and look at this and tell your client, look, if you don't put that there's a $500 initiation fee, you're going to end up paying for that initiation fee as opposed to the buyer. Okay. Last major principle, and this is a big one, once an offer has had a binding agreement date entered, the only way to make changes to that Gar contract package is via an amendment. So after it has been bound or accepted, or if it's an amendment, there's an acceptance date on it. If it's got that date on it, then it is no longer eligible for a strike through and initials to make any type of editing changes on that document. At that point, then what is your only option left for editing that document if you cannot do a strike through and initials?
Add an amendment.
There you go. add that amendment. All right. Any
Hey,
questions
Jay,
on
would
anything there?
errors and omissions insurance have helped Doughboy?
Say that again.
Would errors and omissions insurance have covered that fridge?
No, it wouldn't. It wouldn't just cover the fridge. It would only cover you in case of liability, in case someone came, someone came and submitted a GREC violation against you or took you to court because of that. That's where the errors and omissions comes into play when there are attorney's fees to be able to defend you against something that you did incorrectly. Does that make sense? It's primarily when it's a legal case involved, not something like a refrigerator. Okay. All right. So a couple of additional things about working with GAR contracts. Keep in mind there are at least a handful of places where if you do not have enough room on the standard document, that there's a check mark for additional pages or additional signatures or additional special steps, and use those judiciously. Okay, so where there's not enough room, use the GAR F246 additional special steps. So that's one location where there's additional pages. There's also an additional signature block. What happens if you have an estate property that has 4 owners, the 4 siblings that inherited it from their now deceased parents? You need 4 places for signatures instead of 2. So that's where you have an additional signatures page involved. Okay. There is also just a generic additional page, and that's a GAR F801, and it is not a special steps. It's not a signature page. It's just if you need additional room somewhere else in that document. I cannot remember the last time I've used one of these, but it's there if you ever need it. It's nice to know. Okay. All right. Here's another guiding principle of GAR contract documents, and this is an excerpt taken directly from within paragraph B4.1 or L. I can't tell which one that is. And it is the rules for interpreting this agreement. So anytime a change is made in the contract, this is how the Georgia law recognizes it. So let's read this carefully. In the event of an internal conflicts or inconsistencies in this agreement, the following rules applies for how those conflicts or inconsistencies shall be resolved. These will apply. 1, handwritten changes shall control over pre-written or typed provisions. That's important. So anything handwritten in a GAR document is going to rule over anything that is pre-printed somewhere else in that document. Exhibits control over the main body of the agreement. Okay, so if you have something that is in an FHA exhibit that is in conflict with something that is in the purchase and sale agreement, whatever is in the FHA exhibit is going to rule. Does that make sense? Any questions on that? Good. Special stipulations shall control over both exhibits and the main body of the agreement. Okay, and then notwithstanding the above, any amendatory clause in any FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in a special stipulations, another exhibit, or in the main body of the agreement. All right. Does everybody know what the amendatory clause is? Can't remember if I've got one in here. I don't put one in here, but we can look at one if anybody's interested. In fact, let's do that. I am going to here we go. Claire and I just talked about this earlier this morning. The amendatory clause right here. It is expressly agreed that notwithstanding any provision to this agreement, buyer shall not be obliged to complete the purchase of the property described herein or to incur any penalty or forfeiture of earnest money deposits or otherwise unless the buyer has been given in accordance with the HUD FHA requirements, a written statement by the FHA commissioner or a direct endorsement letter setting forth the appraised value is not less than whatever the sales price is. Okay, so let me paraphrase that. For those of us who don't deal with legal language every single day, which we all do, but we're not attorneys. What that is essentially saying is the buyer cannot be punished because the appraisal comes in low. The buyer cannot be forced to surrender their earnest money on an FHA or a VA exhibit just because the appraisal comes in low. Okay, so remember back in the day when there was so much competition and there was appraisal gap coverages were being written into every single agreement that we were doing. If one of those appraisal gaps special steps was written into any FHA or VA exhibit, essentially the amendatory clause means that it didn't apply anymore. The amendatory clause cannot be overwritten by anything because of that language that says, notwithstanding any other provision anywhere in this agreement, you cannot change this. Does everybody understand that? Okay, so the answer is, the key is, if you're doing an FHA or a VA, because of the amendatory clause, it does no good whatsoever to write an appraisal gap coverage into it. Got it? But this is also an example of how that can't be overwritten. All right, I'm going to go back to sharing my screen and we will continue. Stand by. For some reason, my computer has stalled. There we go. All right, so by far the most common way to edit a GAR contract before it has been bound is through the strike through and initial by both parties. All right, so we're going to talk about this. We're going to talk about some examples of this. I'm going to show you some examples, and I am curious about something. I want you guys to take a look at the samples that I have put into this demonstration. By the way, these are coming from real world experts, real world excerpts of true contracts. And we're going to see, and I want you guys to tell me, do you think this is a legally binding edit to a contract as it stands right now? All right, so in this case, this is a very common occurrence where the time limit of the offer has expired. So one way to, and so you still want, you and the other party want to agree on accepting that contract, but unfortunately you've had one little problem with you didn't get it signed in time. Okay, so a great way to change that is you strike through the date, you rewrite a new date, and you put your client's initials, and then you send it back over. So if I was to turn in this contract as it stands right now to Karen, our compliance broker, and to the closing attorney, is this a legally binding edit in the contract? Chris is shaking his head. Why, Chris?
It expired, so now you have to make a new contract.
No, it's actually legit. Go ahead, Sean.
I'm missing the seller initials there. Got the buyer initials.
There you go. You got the buyer's initials, RAB and BB. They initialed that one, but you don't have EDA and RA, whoever that is over here. Okay, so you still do need those initials on there, but this is a perfectly legitimate way of doing it, Chris. Okay. Let's look at another example. Okay, here is the amendatory clause. This happens a lot. You have to have a number in that field. You cannot just list sales price. So when you initially submitted this document, we were at 165,000. Through the editing process or through the negotiation process, we've agreed on 173,000. So in order to make this legitimate and in compliance with everything, we need to change this here in addition to on the purchase and sale agreement. So this is exactly what we've done. The strike through, written the new amount in, and one side is initialed, and it looks like we're waiting on initials from the other side, but this would also be one that, in my opinion, is not a legally binding yet, but it's on its way to being. Okay, let's look at another example. Great example. In the process of negotiations, we went from 0 days of due diligence to 5 days of due diligence. Can't exactly tell. Looks like two sides of the signatures with only one party on each side. This looks like it's a completely legitimate, no kidding edit that would be in compliance and binding on this agreement. Does everybody agree? More examples. Who is going to be the holder of the alternate holder of the earnest money? It was going to be Century 21. Now it's going to be Gates Realty. I'm not going to fall over my sword over that. It's not a big deal. These are easy changes that can be made in the negotiation process. Okay. Here we have changed from 15 days for verifications of funds down to 5. We've put some initials over here, some off on the margin onto the left. Does this look legit to you guys? Does to me too. One last example. Okay, seller is a licensed agent selling a personal home. And then they also added that the listing agent is the daughter of the seller. Okay, so lots of material relationship disclosures in here, and you see that so both looks like signatures and initials on both sides of these, so we're good to go. One last one. This looks like it came through on an amendment to address concerns. These are all items on the amendment to address concerns, and we just simply confirm that we're taking that one out and putting those initials in there. And it looks like this is only one side of the equation too. Okay, this is an example of something that I don't like is the fact that these are not numbered. If this was 1, 2, 3, 4, 5, and 6, you could say special stipulation or item number 5 on the amendment is no longer part of this agreement. It's an easier way to reference them at some point in the future. All right, so that is some great examples, and we're going to talk some more and show you the mechanics of doing those. Let's talk about the second way of editing our Gar contract, and that is through the amendment. And then it is, of course, the amendment is necessary after the contract has binding or it has been accepted. There is one generic all-purpose, call it generic amendment. It is basically a blank that you can write anything and everything. And there are also 11 special purpose amendments forms. I'm a big fan of using the special purpose forms instead of just the generic one, because it is more clear, concise, and legally sticky if you use one of the special purpose ones. So let's talk about that. Okay, so first is the generic one, which is you simply can write anything and everything in here. And this is a great example where you might use that additional page if you didn't have enough space there. Sorry. And this is where you can basically write anything and everything. You can say that the seller is going to give the dog that the buyer loves along with the transaction is going to stay with the house. That's where you write generic stuff like this. Okay. However, if you have something like I want to change the due diligence period, or we're going to change the sales price, or the closing and possession date, we're going to remove a contingency, why not use the language that is already pre-written by people that are smarter than you and me? Okay. If they're smarter than you and me, we might as well take advantage of that. I want to show you and demonstrate to you exactly where you can access all of these special purpose amendment forms. The easiest way to do it is go into your Remind Docs Plus. In the search bar, just type in the generic word amendment. Okay. And I was going to show you this. For some reason, I closed out a window. Hang on, folks. So say, for example, I'm in one of these and I am looking to add a transaction in here. This one, I want to add an amendment. I'm going to add form. I'm going to come up to the search bar, amendment. And here are all of the ones. Here's the generic amendment to address concerns, amendment to remove the contingency, amendment to due diligence. All of these are available to you. I strongly encourage you to use them and upload them. Okay. Questions about that? that was it from the slide deck. Now we're going to play around a little bit in the next 9 minutes. Bear with me for just a minute. All right, so Claire is going to play a little game with me. We've prearranged today. I have created a transaction, and we're going to just go through and we're going to do some editing and show you some little tips and tricks and techniques for those that are completely inexperienced with this on the call. This might be review for some of you more experienced agents, but we're gonna go through this anyway. All right, so let's just kind of go through the evolution of this for this particular house. Let's just say where we are in this War Hill Park Road in Dawsonville. These are all of the documents that I created this offer, and I've sent it to my list, my friend, or the other agent, who is Claire. Okay, Claire has sent me a counter offer. I now have that counter offer in my email. I need to upload this counter offer, and where did I put it? It is standby signed counter offer. This one. So I'm going to upload it to my transaction. And now you see right here it is at the top. This is the signed counter offer. By the way, just in case anybody's wondering, this is a completely falsified situation. I'm just using blank documents and documents from other transactions, even though it doesn't matter. I'm just trying to give you a demonstration. So here we have a no kidding purchase and sale agreement that's got, looks like it's all here. Has this been bound yet? Let's look. Do we have a binding agreement date? Golly, we do. So in theory, I could not make pen and ink changes on this document. And forgive me, I didn't realize this when I was creating this scenario, the artificiality of the scenario. But let's just say, for the sake of argument and a good example, let's use this date, the time limit of offer. Say, for example, today is the 23rd of June, and we had missed this and didn't get it binding before then. How would we go about making this strike through pen and ink changes? The key is right up here at the top, using the tools that we have up here. So a strike through you can be found here within the drawing. So you can do a strike through, and you can simply draw a line just like that. And then you've got the options over here. You can make that line thicker. You can make it a different color if you wanted to. Whatever your little heart desires, there you go. But anytime you do a strike through, you need to have some initials on here, and you would want to have your client's initials right next to it. Okay? Does that make sense to everyone? And then when you've got it done, you send it over, you sign it and initial it yourself and send it over, and wait for those results to come back. I have showed you. Does anybody have any questions about that? Pretty cut and dry? Pretty simple? Nicole, this is really good for you because you just are learning this stuff. Tip, I don't think you've had an opportunity to do a lot of this. Everybody else has had a little bit of experience, but there's some good reminders and reviews in there. All right. We're finishing a little early. If y'all don't have any questions, we'll go ahead and tie it up here. Have a great day, everybody. Talk to you soon.